It doesn't matter if you were pulled over for no, listen to me. This is why we're hearing stuff all over in the news. It doesn't matter what you think. If a cop pulls you over, then you take the ticket for not wearing your seatbelt. This is all over not wearing your seatbelt.
Welcome back, everyone. Today's courtroom moment is one of those cases that instantly sparks debate. A routine traffic stop spirals into a felony courtroom showdown, and what starts as a simple seatbelt issue quickly escalates into questions of compliance, responsibility, and legal consequences. The judge is clearly frustrated, the defendant is struggling to explain herself, and every second in this courtroom is turning more intense. Was this avoidable from the start, or did things go too far too fast? Let's break it down.
It doesn't matter if you were pulled over for no, listen to me. This is why we're hearing stuff all over in the news. It doesn't matter what you think. If a cop pulls you over, then you take the ticket for not wearing your seatbelt. This is all over not wearing your seatbelt. And here you are in felony court and you're still not taking responsibility.
This is where the judge lays down a core principle of criminal procedure. Once law enforcement makes a lawful stop, compliance matters, whether you agree with it or not. What makes this moment so critical is the escalation. A seatbelt violation alone is typically minor, but refusal to comply during the stop can trigger a chain reaction that turns a simple citation into a criminal charge. The judge isn't just correcting behavior here, he's emphasizing how quickly legal consequences escalate when instructions are ignored in real time.
Refused to go on with it because she didn't accept responsibility for the crime.
Uh-huh.
And then we came back and...
This part reveals something very important about courtroom strategy. Plea decisions are not always straightforward. We hear that there was inconsistency in acceptance of responsibility, which often plays a huge role in sentencing outcomes. Judges and prosecutors heavily weigh whether a defendant shows accountability early or shifts positions later. When someone initially denies responsibility and later changes their stance, it can affect credibility in the court's eyes. This is why attorneys constantly advise consistency. It directly impacts trust and sentencing leniency.
Talking to Miss Johnny about acceptance of responsibility.
I think Miss Johnny said they called and asked her for her updated address, and that was it.
Okay. So, Miss Johnny, I'm going to ask you again, and I know we probably went through this before. First of all, you're Kirsten Johnny. And Miss Johnny, I want to make sure, because in that...
Here we see the judge shifting into a more direct, almost interrogative tone. This is a classic courtroom technique, forcing clarity and preventing evasive answers. The focus is now entirely on the defendant's personal acknowledgement of responsibility. What stands out is how the judge repeatedly tries to anchor her back to facts rather than emotions or financial explanations. This moment is legally significant because it shows the court prioritizing accountability over circumstance-based justification.
Previously, you said you didn't do it, you were forced to do it because of your financial, you were forced to plea because of your financial situation, that it wasn't fair. And so tell me what your position is now.
I never really said I didn't do it. I said it was an accident.
Okay.
I still feel the same way a little bit.
All right.
I'm not going to I do feel the same way.
This is a turning point in the hearing. The judge is directly confronting inconsistency in the defendant's narrative. Earlier claims of being forced versus now describing it as an accident create legal tension because courts rely heavily on consistent statements under oath. What the judge is essentially doing here is testing credibility. If the explanation changes, the court begins to question reliability. This is also where defendants often unintentionally weaken their own position by trying to reframe events instead of clearly accepting or denying responsibility.
But you're not disagreeing that you didn't...
I think it was an accident. Somebody grabbing you by your foot. That's like somebody accidentally hit you in the back of your head. You're going to have something that's normal.
What, right. Because you were not complying with what they told you to do to get out of the car, correct?
I was pulled over because I was in the high road. I stay in the area. I was pulled over because...
Hang on. Don't talk yourself out of this again. Because if you want to talk yourself out of it, we'll put it on the trial docket and we'll get it done in a few weeks and let a jury decide. I'm trying, look at me. I'm actually trying to help you right now. Okay? If you had complied and just done what he asked you to from the very beginning of that stop, none of this would have happened. Do you agree or disagree with that?
Yes.
Yes, what?
Yeah.
No, do you agree? Listen to the question. Do you agree with that
You can feel the frustration building here. The judge is no longer just clarifying facts, He's actively trying to prevent the defendant from legally undermining her own case. This is a crucial courtroom moment because judges often give defendants multiple chances to correct their statements before sentencing becomes stricter. The repeated emphasis on compliance highlights a core legal expectation. During a traffic stop, cooperation is not optional, it's legally required, even if you disagree with the reason for the stop.
Statement, or do you disagree with that statement?
I don't know why.
You don't like it, do you? You don't think he should have done that?
It's not that. I feel like we was pulled over for no reason. If you follow,
It doesn't matter if you were pulled over for no. Listen to me. This is why we're hearing stuff all over in the news. It doesn't matter what you think. If a cop pulls you over, then you take the ticket for not wearing your seatbelt. This is all over not wearing your seatbelt. And here you are in felony court, and you're still not taking responsibility for the fact that he said, hey, ma'am, do this. And you said, I don't think you should have pulled me over. So I'm going to do whatever I want to do. And I'm going to lodge my foot against the door, and I'm not going to get out. I'm going to make you drag me out of my car, and then I'm going to kick you because you shouldn't have pulled me over in the first place. When all you had to do was get your ticket, go to JP court, and try to fight it there legally. But here you are in felony court for a second-degree felony instead. So do you want to try to tell that story to a jury, or do you want to accept some responsibility today?
I don't feel like one.
You don't feel like going to trial. Well, there's two parts to that question. Do you feel like accepting responsibility? Do you think it would be a better idea next time you're pulled over to comply and just do what they ask you to?
Yeah. And Your Honor, just for the record, Miss Johnny did review the video with me in my office, so she is aware of what all transpired. She saw it.
Do you have any reason to believe she shouldn't be pleading to this from what you saw?
I do not.
So, you even saw how you acted. It's probably a good idea. All right. I'm going to find that you previously entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney. I hope you prove me wrong on this, because I really have some concerns that you're going to be able to be successful, because you're not taking responsibility and you're not wanting to follow directions and things like that. And you're about to have 4 years of having to follow directions on probation. So I'm going to defer all proceedings for 4 years. You're ordered to pay a $500 fine. You're ordered to follow all of the rules and conditions.
Now the tone shifts dramatically from discussion to consequence. The judge is essentially laying out a legal fork in the road, trial versus acceptance of responsibility. This is where courtroom pressure becomes very real. When a judge mentions jury trial possibilities and sentencing exposure, it's not intimidation, it's legal transparency. The defendant is being given a final opportunity to choose accountability over uncertainty, because once a jury trial begins, outcomes become significantly less predictable.
Of probation. If you do that, this is a great opportunity today, because you are not a convicted felon. You don't have the conviction on your record. And if you successfully complete it, follow all of the rules, you will never have a felony conviction. At the end of your probation, the case will actually be dismissed. The other side to that, though, and this is really important for you to understand, because we've had this conversation now so many times, I'm not likely to forget you. And you can ask anybody, and Ms. Holmes has known me for a long time. It's not usually good when I remember people, right? So if you violate your probation, you'll get brought back into court. You could be found guilty, which means you become a convicted felon, and I can sentence you to prison anywhere in the range of punishment, which is up to 20 years in prison for this. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed. So you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will go over your paperwork as soon as they're ready.
Okay, well, you said that I'm not considered a conviction felon, but I was told that even though you say that, it's still going to be on my record.
So the arrest is on your record. The arrest will always be on your record. But so if you're asked a question on a filling out an application for a job or something, if it says, have you been convicted of a felony? The answer is no. But if it says, have you ever been charged with a felony, or are you on probation for a felony? You are going to have to say yes to that. But the conviction part is still better than nothing, not having that conviction, right? Okay, have a seat in the courtroom. Watch for probation to call you up.
Ultimately, this case highlights how a minor traffic stop can escalate into serious felony exposure when compliance breaks down. The court's decision focuses heavily on probation rather than immediate incarceration, offering the defendant a chance to avoid a permanent felony conviction if she follows strict conditions. But the judge's warning is clear: probation is not leniency, it's a test of behavior over time. One violation could completely change the outcome. This case serves as a powerful reminder that courtroom decisions aren't just about the past, they're about proving future accountability.